Good morning. Welcome to the COVID-19's impact on the Massachusetts construction industry webinar. This is an interactive presentation and we welcome your questions. We will have a question and answer session after the presentation. Please use the Q&A section to submit your questions and our speakers will answer as many of those questions as possible. Quick reminder, the purpose of this presentation is for information only. Communication with any member of Bernkopf Goodman LLP in this forum does not establish an attorney-client relationship. Confidential or time-sensitive information should not be discussed on this forum. Speaking today, we have Bernkopf Goodman litigation partners Peter McGlynn and Bob Stetson. Both Peter and Bob are members of Bernkopf Goodman's Construction and Surety Law Practice Group. They are both fellows in the Construction Lawyers Society of America and have both been recognized on a national level for their work in construction litigation and commercial litigation. Peter McGlynn also has extensive bankruptcy experience and is certified in business bankruptcy law by the American Board of Certification. Peter, let's start with you.
Well, good morning all and welcome. Thank you all for attending. We sincerely hope that you are now and will remain safe and healthy. We will try and maintain a semblance of normalcy during these very challenging times. Regrettably, COVID-19 and its impact on the construction and real estate development industries has brought us here today. For the next 35 or 45 minutes, Bob and I will provide on an alternating basis discussions on 6 different topics. And following that, as Jeanette indicated, we'll answer as many written questions as time permits. The first and our primary topic concerns the construction suspension orders issued by the cities of Boston and Cambridge, and apparently more recently, the town of Walpole, Massachusetts, and Governor Charlie Baker's emergency order that he issued this past Monday. I'll briefly summarize these 3 orders for you. Effective on March 17, 2020, Boston Mayor Marty Walsh ordered the suspension of all construction activity in Boston. Work crews had until this past Monday to render the construction sites safe and secure, and thereafter only quote-unquote essential work can be performed. Essential work must be approved by Boston's Inspectional Services Department, and waivers will only be granted on exceptional circumstances. May we have the first slide? All right, this is a brief summary of the essential work that is permitted under Mayor Walsh's suspension order. Essentially, it's limited categories of truly emergency work: repairing gas leaks, water leaks, sinkholes, new utility connections to occupied buildings, mandated building and utility work, obviously work at healthcare and shelter facilities, and work necessary to render occupied buildings habitable. As I'd indicated, waivers are only going to be reviewed on a case-by-case basis, and it's really going to be upon exceptional circumstances. This particular suspension order remains in effect at least indefinitely and will be, quote, reviewed at regular intervals according to the Mayor Walsh's website. The Seaport District is a bit of a different story. The Seaport District comes under the jurisdiction of the Massachusetts Port Authority, and therefore that work is not subject to the mayor's order. The Mass Port Authority is a quasi-political subdivision of the Commonwealth, and to our knowledge, it has not issued any suspension orders thus far. It may very well be due to Governor Baker's emergency order, which was issued this past Monday, and I'll discuss that shortly. The City of Cambridge, effective March 18, issued a similar emergency order. They call it a moratorium over there, but it's all construction work, both public and private, and it is also going to be of indefinite duration. There is an exemption for so-called essential work, but only subject to the permission of either the Commissioner of Inspectional Services or the Commissioner of Public Works. It's going to be on a case-by-case basis review, and the touchstone is that you have to prove that the work is, quote, essential for public safety, end quote. May I have slide 2, please? There are guidelines similar to Mayor Walsh's suspension order, but it's essentially the same thing: essential work, emergency work to repair leaks, utility failures, electrical and plumbing, and so on. COVID-19 related work to healthcare facilities and shelters, and work to maintain safety at construction sites, and work necessary to render occupied buildings habitable. There is one carve out in the Cambridge suspension order, or excuse me, moratorium, and that is that it does not apply to construction work on 1 to 3 family residential structures that have already been permitted as of March 18, 2020. This past Monday, March 23rd, Governor Charlie Baker issued an emergency order declaring that there exists, and I'm quoting from the order, in the Commonwealth, a state of emergency due to the outbreak of the 2009 novel coronavirus, also known as COVID-19. Under Governor Baker's order, all non-essential physical workplaces and facilities have been closed as of noon yesterday, at least until April 7th, unless the governor's order is extended. Significantly, for purposes of this webinar, the governor's list of, quote, essential services, end quote, exempts from the governor's order virtually all construction and related activity. May I have the next slide, please, which is number 3. Essential services at the bottom bullet include construction workers, construction service providers such as plumbers, electricians, and exterminators, local and state inspectors, hardware, home improvement, and appliance stores such as Home Depot and Lowe's. These are essentially non-exempt and will be permitted. However, the governor in his order recognizes that, of course, COVID-19 does present a clear and present danger to our health, and recommends that individuals working on construction projects continue to practice social distancing protocols. This, of course, is very important, ladies and gentlemen. In fact, you may have seen the night before WCVB Channel 5's 7 p.m. news broadcast, where they interviewed a number of workers over at the seaport, which of course is not subject to the suspension order, who expressed concern about how difficult it was for them to practice social distancing in the workplace. And apparently to address these concerns, Governor Baker issued a supplemental set of COVID-19 guidelines and procedures for construction sites yesterday, which seems to be his effort to try and address these concerns expressed by these workers in the Seaport District specifically. Now, the issue which is just really come to head in the last 18 hours is, does Governor Baker's order supersede the orders of Boston, Cambridge, and Walpole? The governor's emergency order states, and I quote, "It supersedes any order or rule issued by the municipality that will or might in any way impede or interfere with the achievement of the objectives of this order." And may I have the next slide, please? This is number 4. This is, ladies and gentlemen, this is a direct quote from the governor's emergency order. The highlights have been provided by us just to emphasize certain portions of this rather lengthy paragraph. But basically, and putting it more bluntly, Governor Baker's emergency order also declares as, quote unquote, inoperative any municipal order that impedes or interferes with the provisions of this order, as well as having the effect of interfering with, quote unquote, free travel of any person who is a member of any COVID-19 essential workforce in connection with COVID-19 essential services. This seems to be pointed directly at Cambridge, Boston, and more recently, Walpole. The question is, what impact does Governor Baker's order have, which declares that on an emergency basis that COVID-19 essential services include construction work? And how does that interface, if it does, with the suspension / moratorium orders of the cities of Boston and Cambridge and Walpole? 2 lawyers that I know recently and who I greatly respect, have recently said that Mayor Walsh's suspension order remains in effect despite Governor Baker's emergency order. Ladies and gentlemen, it's also often been said that if you ask 10 lawyers their opinion on a legal proposition, you'll probably get 10 different opinions. That may be the case here. We've looked into this issue reasonably carefully, given the time constraints of between then and this morning. And we believe that the governor's order does, in fact, legally supersede the Boston and Cambridge orders. And here's why. First, Governor Baker declared a state of emergency under a law enacted in 1950, the Civil Defense Act, at a time of course, the height of the Cold War, and of course, the people were concerned then not about COVID-19 or biochemical warfare, but a nuclear holocaust. But the parallels are the same. That particular 1950 Act, the Civil Defense Act, provides the governor the ability to declare a state of emergency and gives him expanded powers, quote, necessary and expedient for meeting the state of emergency, including issuing executive orders which supersede other inconsistent laws, rules, and regulations and ordinances. Next slide, please. This is number 5. These are just highlights of the Civil Defense Act and the very broad, extensive powers that are conferred by that act onto the Massachusetts governors. These powers include issuing orders to quote unquote political subdivisions, which by law include cities and towns. Third, as political subdivisions of the Commonwealth, cities and towns are subordinate to the laws of the state, especially in times when an emergency has been declared. In this case, ladies and gentlemen, the positions of Governor Baker and Mayor Walsh have hardened within the last 18 hours. Yesterday afternoon, you may have seen Mayor Walsh's press conference where he reaffirmed his previous order halting all construction work in the city of Boston, except of course in the Seaport District. And then shortly thereafter, Governor Baker reiterated his position that his emergency order stands and it supersedes any contrary orders by cities and towns. Shortly thereafter, his chief legal counsel, Robert C. Ross, sent a letter to every chief executive in the 351 cities and towns in Massachusetts, essentially stating that the governor's emergency order renders inoperative any inconsistent orders by cities and towns, and he directed these chief executive officers in these cities and towns to, quote, withdraw any local policies, regulations, or directives in direct conflict with the emergency order. So, ladies and gentlemen, the legal and political battle lines have been drawn, and this is as much a political conflict as it is a legal one, and it's really difficult to predict the outcome. However, as I stated a few minutes ago, legal minds often differ, especially when we're talking about nettlesome questions of the primacy of state versus local law, and issues that have been rendered much more complex and sensitive by well-intentioned public officials, but who have issued conflicting orders, and unfortunately, something that we have not experienced for approximately 102 years since the Spanish flu pandemic of 1918. Now, hopefully there'll be a political resolution of this conflict in order to avoid potentially protracted litigation. That's, of course, equally problematic because most of the courts are, in fact, all of the courts are closed except for some very limited emergency matters. So stay tuned. There'll obviously be further developments on this as the days progress. Bob, I believe it's your turn to discuss the next topic.
I think you're going to do the general conditions and the delay claims.
You want me to do that? I'm sorry. Yeah, that's my apologies. All right. Bob will be discussing some so-called common law rights and remedies that may be available to contractors and owners in this time of shutdown, at least in Boston, Cambridge, and Walpole. I'm going to discuss some contractual provisions which may also be applicable. The question is, do owners have and contractors have any legal recourse for the costs and damages caused by these shutdowns? The answer is, speaking like a lawyer, it depends. First of all, any thought that any of you might have about suing the cities of Cambridge or Boston or Walpole should be quickly dropped. People rarely are successful in these battles, especially in connection with elected officials exercising their political and police powers in times of a public safety emergency. But as for contractors and owners, their rights largely depend on what's in the contract documents. Generally speaking, governmental orders are beyond an owner's and a contractor's control. These events are commonly known as force majeure events. That's a French term meaning superior force, and it's usually invoked and involves circumstances such as wars, strikes, riots, plagues, hurricanes, floods, and earthquakes. But ordinarily, force majeure concepts are not inherent in contracts. And except for specific common law remedies, which Bob will discuss, relief for force majeure events generally has to be included in contract documents. They have to, those rights have to be specifically bargained for. One of the most common forms of construction contract documents is published by the American Institute of Architects, and their AIA general conditions have been around since approximately 1917. That standard form, in its most recent iteration, 2017 version, has the equivalent of a force majeure clause in section 8.3.1. May I have that next slide, which I believe is 10? Slide 10. It's a slide 10, please. There we go. Just before that. All right, there you go. Thank you. This is a force majeure clause, only it's not called a force majeure clause. It obviously deals with delays and time extensions for various events on a construction project, acts or neglects by the owner or the architect, changes in the work, labor disputes, unusual delays in deliveries, and so on. And then number 5 is other causes that the contractor asserts and the architect determines justify delay. This would essentially be that clause by which contract time extension relief would be afforded to the contractor. There is another provision, 8.3.3. That's the next slide, I believe. There we go. That specifically says that 8.3.1 does not preclude damages for delay by either party under other provisions of the contract. So AIA contemplates that parties can and often do provide for this type of damage delay relief, but it has to be specifically bargained for, and it is not otherwise found in the standard form AIA language. Now, this particular clause, and I'm referring back, of course, to 8.3.1, tries to strike a balance, and I should back up and say that these contract documents by AIA and a lot of the other standard forms that are out there are really negotiated. It's almost like legislation. There's an effort to try and strike a proper balance between the counterparties to this contract, owner and contractor, of course, with the architect involved as well, because this is a document published by the constituencies of architects here and engineers to a certain extent. But the 8.3.1 tries to strike a balance by not burdening the owner with the costs of standby time, idle time while the suspension order is in effect, but also provides relief to the contractor in the form of a time extension, so that if, for example, there is a liquidated damage or delayed damage clause, the contractor is not burdened with those damages during a time of delay, especially with respect to a governmental order. But with respect to the contractor under the standard form language, there is no compensation that's afforded to the contractor, simply a time extension. There's another nationally recognized set of forms published by an entity known as consensus docs. Not as well known as AIA, but well regarded and in use. And consensus docs has an analog to AIA A201 section 8.3.1, and that's found in section 6.3.1 of Consensus Docs 200, which is the equivalent of the AIA 201 general conditions. Next slide, which is, I believe, 12. There we go. Thank you. You can see that 6.3.1 is a little bit more robust in terms of its detail. This is, again, a form of a force majeure event clause, but it specifically enumerates, among other things, epidemics and adverse governmental actions as causes for contractor relief in the form of a time extension. And similar to A201 section 8.3.1, only a time extension for such things as epidemics and adverse governmental actions is permitted. It talks about an equitable adjustment of the contract time. That's essentially a legal term that's been around for at least 100 years, grounded in government contract law. Literally volumes of case law has been written on what constitutes an equitable adjustment. It would be the subject of a full-day program to describe that, but that's what this particular clause calls for, an equitable adjustment of the contract time. Now, these are just two of the literally dozens of standard forms that exist out there for contractors and owners. They all contain largely similar clauses to what we've just discussed here with respect to the consensus docs and A201 general conditions. But in the public sector, for federal contracts, there's what's known as Federal Acquisition Regulations, FARs, and they have in regulation 52.249-14, a form of a delay provision, a force majeure provision, that does also provide for a time extension for these types of force majeure events. The Commonwealth also has its own standard form public contract. It does also provide for a time extension, but for at least 50 or 60 years, it has been steadfast in not entitling the contractor to any delay damages, whether they were avoidable or unavoidable. No damages for delay clause, if you will, but the contractor is entitled to a time extension. That's all I have on that topic. Back to you, Bob.
Thank you, Peter. Good morning again. I want to echo Peter's sentiments. I hope you and your families are staying safe during these strange and difficult times. And on a separate note, my family thanks you all for giving me a reason to shave this morning. The next topic, I think, which is a nice segue from Peter's last topic, is terminations. And let's start with the owners. So let's assume that the force majeure clause, the delay clause in your contract allows for delay damages. So owners, what do you do when you have an already tight budget and you get hit with a valid coronavirus-related claim for $2 million? One option is to terminate the contract for convenience. We see the language from the AIA A201 form, section 14.4.1. The owner may at any time terminate the contract for the owner's convenience and without cause. So this provision was specifically designed as an opt-out when there was some change circumstance on the project, such that it makes the project difficult to complete or even unnecessary under the circumstances. This concept of a termination for convenience is one that was actually borrowed from government contracts for the history buffs out there, the federal government started using these in wartime procurement contracts after the Civil War. And really the purpose of the clause was for the government to avoid being saddled with contracts that they didn't need or couldn't fund once a peace treaty was signed. Most of you owners and developers have probably never considered using this provision because ordinarily it comes at a cost. The AIA form, for instance, includes the concept of a termination fee. But desperate times call for desperate measures, and the termination for convenience may be appealing depending on how long this crisis continues and your particular financial circumstances. Next, we have contractor termination. This is slide 11, Jeanette. Here's a summary of the different triggers under section 14.1 of the A201 form for contractor termination rights. So you can see up there at the top, 14.1.1, contractor may terminate if the work is stopped for 30 days due to public authority shutdown, act of government, non-payment, and if the owner fails to provide financial evidence. 14.1.2, owner suspends work for more than 120 days in a year or more than 100% of the days scheduled for completion of the project. And then 14.1.4, if work is stopped for 60 days due to owner's breach. And this would be a non-monetary breach. So I'm going to run through a couple of these in greater detail. The first is public authority shutdown. Although this provision might appear sort of on its face to apply under the circumstances, particularly in Boston, Cambridge, or Walpole, it typically refers to a project being shut down by a building inspector or court order. So it probably would not apply under the circumstances. The second one, however, an act of government, that's directly on point. That's precisely what we saw in Boston, Cambridge, and now Walpole. And of course, based on the position that Peter outlined earlier, we believe that Governor Baker's order allows for construction to move forward even in these jurisdictions, and thus hopefully not for the 30 days sufficient to trigger contractor termination provisions. The next one is non-payment, which is self-explanatory. The last one there in 14.1.1 is reasonable evidence of financial arrangements. This provision is one to keep an eye on, particularly if the situation around the country and the world continues to deteriorate. So under section 2.2 of the A201 form, an owner is required to provide, quote, reasonable evidence of its financial arrangements for the project. Now, once the project itself begins, an owner is only required to update that information if the contractor identifies in writing, and I want to quote this, reasonable concern regarding the owner's ability to make payments when due. So if the contractor submits a request and has a reasonable concern about the owner's ability to make payments, the owner has 14 days to provide adequate evidence. Otherwise, the contractor can stop work, and that would trigger the 30-day period. So the question is, what do these terms mean? What is reasonable evidence? What is reasonable concern? Basically, when do these provisions apply? And overall, there is really a dearth of case law that has examined these points, and the circumstances in which these provisions could come into play are virtually limitless. For instance, is evidence of a construction loan enough? In ordinary times, probably. But what if the owner's flagship tenant went out of business? And it's unclear, legitimately unclear, whether the owner can service the debt. So under those circumstances, maybe not. While we don't know at this juncture really the answers to these questions, it's possible that we'll be fleshing them out in the weeks and months to come. The next one is owner suspension. That's self-explanatory. And the last one there, 14.1.4, this is owner's breach. Although it's sort of hard to imagine a non-monetary owner's breach that would lead to a shutdown of a project for 60 days, what if an owner's architect goes out of business? An owner who has an obligation under the contract to provide drawings and plans is unable or unwilling to retain a new architect, and the project grinds to a halt. You know, this again is not inconceivable in tumultuous times. It's just a situation that hasn't been examined all that much during sort of the last 10 years at least. Jeanette, next slide. So the next topic, as Peter alluded to earlier, is the common law defenses of frustration of purpose and commercial impracticability. I've received quite a few calls about this in the past week or so. The essence of the question is, what happens if I simply cannot perform the project due to coronavirus issues? So the short answer, as Peter discussed in depth, is, you know, let's look at your force majeure clause. And this is why, here's the shameless lawyer plug, you should always talk to your lawyer when you're drafting your contracts. But let's assume for a moment that your contract doesn't address your particular circumstances. You may have some common law defenses. The doctrines of frustration of purpose and commercial impracticability are closely aligned, so much so, in fact, that in Massachusetts, they're treated exactly the same. And here's what the Massachusetts courts say about it. When an event neither anticipated nor caused by either party, the risk of which was not allocated by the contract, destroys the object or purpose of the contract, thus destroying the value of the performance, the parties are excused from further performance. So what does all that legalese mean? I think the best way to explain it is to talk about the famous case of Krell versus Henry. This was part of a series of English cases known as the coronation cases. So up there on your screen, you see King Edward VII. In 1901, when King Edward VII ascended to the throne in England, his coronation day was highly anticipated. Krell, who owned an apartment with a good view of the coronation route, decided that he was going to rent it out at a premium for people who wanted to use it to watch the coronation. Henry agreed to rent it for that purpose. However, the contract did not specifically address anything about the coronation. So when the king fell ill and the coronation was postponed, Henry did not use the apartment and he refused to pay Krell. So Krell sued. The court actually found that the coronation, while not addressed in the contract, was a fundamental premise of the contract, the failure of which could not have been foreseen by either party. And when that failure occurred, the contract became unenforceable. So the touchstone, the lesson and the touchstone of this analysis is whether or not the occurrence or non-occurrence of that premise, that fundamental premise upon which the contract is based, the king's coronation, whether or not the occurrence or non-occurrence of that is foreseeable. Put differently, the Supreme Court has noted if the risk was foreseeable, there should have been provision for it in the contract. And the absence of such a provision gives rise to the inference that the risk was assumed. So there won't be a defense available if it's a foreseeable risk. So the last time that we really saw these defenses popping up on a regular basis was in the wake of the 2008 financial crisis. And most courts that looked at the issue held that financial difficulties, even extreme financial difficulties, were insufficient standing alone to support these defenses, the defense of frustration of purpose and commercial impracticability. The reason is that, generally speaking, market fluctuations are foreseeable from a legal perspective. But of course, the devil is in the details. So bringing this into the age of coronavirus, we'll call it, is it foreseeable for a contractor to lose 3 or 4 subcontractors on a particular project due to economic conditions? Yes, that probably is foreseeable. But Is it foreseeable for 75% of your workforce to fall ill and become unable to work at the job? Probably not. And let's talk about developers for a moment. We can use the example of the Olympics since that was in the news this week. What if a developer agreed to build a sports facility for the Olympics and hired a contractor for that purpose? But the Olympics, instead of being postponed, is canceled or moved to an entirely different country. Does the developer have an out? He may very well, even if the contract doesn't specify that he does. The next topic and last topic I'll be discussing is business interruption insurance. Business interruption insurance covers lost revenue under certain circumstances that are insured by your commercial property or business owners policies. The question, of course, on everyone's mind is whether or not pandemic qualifies. So there was a case, probably the first of many, filed down in Louisiana recently, where a restaurant owner has alleged that his policy covers its coronavirus-related business losses. So I think in order to understand that lawsuit, we got to take a look at the language, which, well, thank you, Jeanette. It's already up there. So this is the language involved in that case, and it's actually pretty useful because this is pretty standard BI language. It says, we will pay for the actual loss of business income you sustain due to the necessary suspension of your operations during the period of restoration. The suspension must be caused by direct physical loss of or damage to property. So the question generally in these cases is whether or not virus contamination, if your property even has that, is or can ever be considered direct physical loss sufficient to trigger coverage. So for instance, there's a big difference between your business being shut down for contamination and some of these sort of prophylactic orders that have been issued by state, local, and national officials. So let's assume that your property gets shut down for contamination reasons. Although there are some creative arguments to support that coronavirus contamination could satisfy this requirement, the better reasoning is that it is inadequate. One court, in not dissimilar circumstances, concluded in these terms: the mere adherence of molecules to a porous surface without more does not equate to physical loss. So in other words, some damage, more than germs that can be cleaned and sanitized, is going to be required in order to trigger this type of coverage. So the other issue raised in the Louisiana lawsuit relates to civil authority shutdown coverage, which is sort of a related coverage. Some people, some locals, may remember that several businesses in the Newberry Street and Boylston Street areas received BI coverage under this provision after the marathon bombings. And I've gotten a couple of calls on this as well, and people are saying, well, some of those businesses didn't have physical damage. That's true, but the situation was different for a few different reasons. The first is that there was, in fact, physical damage in the area to some of the buildings, specifically on Boylston Street. Number two, from a cost and risk analysis perspective for the insurance companies, the claims that they were faced with were, a drop in the bucket compared to what we're likely to see under these particular circumstances. And then, of course, there were probably some public relations considerations that went into those settlements. So the point is, generally speaking, even civil authority shutdown coverage is going to require some physical damage. This issue was actually litigated extensively after 9/11, when some of the airlines sued their insurance companies after the FAA ordered some of the airports closed. And in those cases, the courts rejected coverage because the shutdowns were related not to the property damage in New York and DC, but to the potential for future attacks and property damage which had not yet occurred. So as I mentioned before, prophylactic measures such as the airport shutdowns or the stay-at-home orders that we've seen, those are generally not sufficient. So The short answer, which I'm sure will disappoint everyone, is that BI insurance is probably not going to assist under these circumstances. However, there are several attorneys and insurance specialists that are recommending that businesses document and possibly even file their claims because of the possibility for government intervention or class action settlements, even if the claims are not terribly strong from a legal perspective. So thank you, Peter, back to you.
Thank you, Bob. Well done. Thank you for not keeping Edward VII's picture up there. I think he has a little more hair than I do, and he was older at the time. Last but most assuredly not least, we're going to talk about bankruptcy. Many say that the bankruptcy court is the court of last resort, and obviously it's something that is on a lot of people's minds these days. Just some up-to-date news in that regard. According to NYU Stern School of Business professor emeritus Ed Altman, he says that bankruptcy and default potentials for high-yield companies has doubled in just 2 weeks. We also have learned that industries that are likely to file bankruptcy within the next few weeks include the airlines industry. American Airlines apparently is contemplating it right now. Retail. The news this morning was Neiman Marcus is seriously considering filing bankruptcy, as well as the automotive and healthcare industries. And while the construction industry bankruptcy deluge does not appear to be imminent, as the economy shrinks, so too will, of course, construction spending shrink. So thus, in the event that there are bankruptcies within the chain of those entities working on a construction project, from owners down to suppliers, there are a couple of key things that you should keep in mind. Hopefully, they are only things that you'll keep in mind and hopefully never experience. But the first thing is that when an entity files for bankruptcy, that entity is called a debtor in possession. And what happens at that point in time is that when that debtor files, an automatic stay statutorily created by the bankruptcy code is created. It's almost like an invisible shield around the debtor. Nobody can file a lawsuit or continue to prosecute a lawsuit against the debtor. Nobody can declare a default or terminate a contract or seize assets except as otherwise permitted by the bankruptcy court in advance. Any of those remedies, even if permitted, may have other far-reaching consequences as well. But it's safe to say at this particular juncture, if you're ever confronted with that particular problem, get bankruptcy court approval beforehand, especially if you're talking about terminating a contractor for default. There are some exceptions, such as, for example, perfecting or continuing a mechanics lien in place, or perfecting or extending a UCC security interest. But other than that, you got to get the bankruptcy court to approve it. The second takeaway, the second important aspect of a bankruptcy is a unique remedy that is largely only involving insolvency situations, and that's known as the preference action. If, for example, you've been paid by a payor for an antecedent, in other words, an old debt, within 90 days of the payor's bankruptcy, that payment can be recoverable by the debtor as what's known as a voidable preference. What the objective is to get all of these preferential payments back into the estate, and then they are more equitably distributed to all creditors and not just those that have been benefited by this preferential payment. And finally, normally parties to a contract only have the right to terminate the contract for default or for breach, or, as Bob alluded to, termination for convenience, but only if that's permitted in a contract document. However, a debtor has a right, again, subject to bankruptcy court approval, which generally is routinely granted, because a bankruptcy court is not going to interfere with a sound business judgment of a debtor, to reject what are known as executory contracts. Executory contracts are contracts where both parties have not fully performed their contractual obligations. That's, of course, typical for a construction contract. And the debtor has a right to reject executory contracts, with the theory being that the debtor has this right to unburden itself of unprofitable or unduly burdensome contracts, so that it gives the debtor a better chance to that fresh start concept, which a lot of bankruptcy commentators have talked about for 50 years. So this is something that you also have to keep in mind, whether it's an owner that is the subject of a bankruptcy petition, or a contractor, or a subcontractor, or even a supplier. There is this right to reject contracts, and very rarely does the counterparty have the ability to successfully oppose that rejection. Historically, this has been done by businesses where they want to reject, for example, what they claim to be unduly burdensome union contracts and things like that. But it certainly can be the case with respect to construction contracts as well. So those are the three things to keep in mind in the unfortunate and hopefully unlikely event that there are any bankruptcy filings in the construction trades in the near future. And I believe that concludes the presentation, and I want to thank you all for attending.
Peter,
and yes.
we do have a few questions.
All right, well, I was just going to say that we have time, and Bob and I will be happy to answer written questions within the whatever time limits we have now on this webcast. But thank you all for attending, and again, be safe and healthy.
Before I jump into the questions we have already, if you do not see the Q&A section, just hover your mouse near the bottom of the web browser window and it should pop up. The first question I have is from Jennifer. I feel like we are watching mom and dad fight over letting us play with a toy. I'd be curious to hear about any thoughts on who will be enforcing these conflicting restrictions, and if there has been any language outlining the repercussions. Will it result in fines, court hearings that could take weeks or months to execute, shutdown orders that would exceed the current SIP timeframe, etc.?
You want me to take that, Jeanette?
Sure.
The answer is we don't know. Neither of these suspension orders on the state level or on the local level have any express penalties that were written in them. That nothing that says whoever violates this is subject to such and such a penalty. I suspect on the local level, assuming that that Mayor Walsh and the Cambridge suspension orders stand, that perhaps they could move to revoke a building permit or implement some other sanction, whether it's a fine. It's undefined, and that probably requires cobbling together a lot of state municipal laws and regulations to find out what the penalty would be. So I don't know. Governor Baker's emergency order of March 23rd also does not have any specific penalties for violation. So that, I think, answers the first part of that question. The second part, enforcement. It's unclear whether Mayor Walsh or Governor Baker are going to challenge this in court. I think that's probably politically non-expedient. The courts are, as I'd indicated, they're closed, other than emergency relief. How quickly you can get a hearing, obviously, this is very important. So I think it would be put on the top priority list. But still, the courts are shut down, and unfortunately, at the state court level, we are not very well electronically orientated. In the federal courts, papers get filed electronically. Not so in most, but not all of the state courts. So I'm not sure that this is going to be Governor Baker versus Mayor Walsh. Maybe, and I don't know this, but there are, of course, a number of trade organizations out there that represent contractors, subcontractors, owners, and so on. Whether or not they are considering mounting a challenge, either way, I don't know. But I'm sure that all of this is broken within the last 18 hours. So I suspect maybe in the next 18 to 24 hours, we'll have a better answer for that that question. So yes, it is a political as well as a legal battle. I think that both of these executives, chief executives of their respective constituencies, are trying to do what they feel is best for their constituencies, given the obviously increasing spread of the COVID-19 virus. But I don't know how that's going to turn out. I hope it gets resolved politically.
If I could just jump in there, I think the question really raises some really interesting issues in the event some owners or contractors decide that, hey, you know what, we think the governor has given us some cover and we want to go back in and start working again. So what happens? And, you know, if the Boston Police Department comes in and starts arresting people and shutting down projects that way, that's one consideration. If there are fines that may or may not be imposed until, you know, after the shutdown order, that's another consideration. And the reason I say that is because, you know, as Peter mentioned, we feel as though the governor's order does give appropriate cover to owners and contractors who want to work. And, you know, if there is a brave and contractor or owner that wants to go into court and test that out, you know, that might be a test case that will kind of change the way that people view this thing. Until that happens and until sort of these legal issues get hashed out, it really does look to me more like a political battle, which to me, again, just an opinion, but it looks like Mayor Walsh has won it.
I guess to that, is there a Mr. Krell in the audience that is interested in firing a shot at the king?
There's kind of a follow-up question to what you just said, Bob, and she wrote it before you answered it, so you may have kind of covered it, but Paulette asked, are any contractors attempting to exercise any rights under your interpretation that Governor Baker's order supersedes Mayor Walsh's order?
I haven't heard of any specifically that are interested in sort of defying Mayor Walsh's order. I think a lot of us thought that this was going to be worked out politically in the last couple of days. I suppose there's still some hope, but after watching Governor Baker's press conference yesterday, in which he basically shrugged and said, I hope Mayor Walsh changes his mind, I think that those negotiations are probably over. So the answer is I don't know. I think everybody is probably just trying to digest this at this point. And, you know, what I would say is if you are considering it, you know, you're fixing for a battle, both legal as well as a public relations one. And you really need to make sure that you've got all of your ducks in a row, that you're going to be operating the site with extreme safety precautions. And of course, if you are thinking about that, you can kind of give Peter or I a call or shoot us an email. And we can kind of talk about that a little bit, but you know, there's certainly a risk there.
June put in a comment, not necessarily a question, but she said that she received information that Waffle is now complying with the governor's order and is allowing work to continue.
Again, the ever constantly changing. Thank you, June. That's something that we were, at least I was unaware of.
Me either.
Craig asks, as a contractor, would filing as an essential business with the state strengthen my case to return to work?
Well, the answer is if you're working in, well, for example, in Walpole, you don't have anything to worry about. If you're talking about in Boston, the question is not whether you qualify as an essential service under Governor Baker's order, but I think more in this Baker versus Walsh battle, whether or not you come under one of the exceptions to Mayor Walsh's order. If you want to go and resume construction work in the city of Boston, obviously that is in violation of Mayor Walsh's order. Whether or not that's enforceable, that's something that has yet to be debated carefully and considered and obviously decided.
Okay, this is from Andrew. We are currently working on a public project for the City of Boston Public Facilities Department. They have not specifically told us to stop working and are just referring us to the Inspectional Services Department's comment saying that we are on a, quote, temporary pause. The Public Facilities Department has never told us directly to suspend work. Is the Inspectional Services Department and Mayor Walsh's comments sufficient to stop working? And should those comments be considered as coming from the owner when looking for a request for an extension in time if this goes past 15 days?
First of all, I can't give you any specific legal advice, but let me give you some general thoughts. Number one, I suspect that the city has not ordered a suspension, at least from public facilities, because there are probably contractual rights under the suspension and delay clause, which Bob was talking about earlier, that may give you greater rights than you would otherwise have. So you got to check your contract's suspension and delay provisions. But other than that, you should certainly check your contract to see what type of remedies you have in the event that the project is shut down. It's essentially shut down even if the Public Facilities Department has not invoked a particular suspension or delay clause in the contract. You got to look at the contract, consult with your lawyer, but I would, at this point, the work has been shut down. Everybody was ordered to secure the projects, I think, by this past Monday. And so that's what you should be following, unless you want to try and maintain take some kind of a position that the Governor Baker's order does in fact, as a matter of law, supersede Mayor Walsh's order. But I certainly wouldn't do it unilaterally, because you may have, the Boston Police Department knocking on your door.
We are almost out of time. Peter and Bob, do you have anything else you would like to share before we wrap up? Anything, maybe questions that your clients are asking you directly?
The only thing I'll add is that obviously this issue, as of 9 o'clock or not, 9 o'clock, has not been resolved. If it gets resolved, it's going to take some more time, and we'll perhaps supplement this webinar with an additional webinar down the road if, as and when developments warrant it. But other than that, I don't have anything further other than to thank you all for your attentiveness and some excellent questions.
Yes, thank you from me as well.
Great, thank you very much. If anyone has any additional questions after this webinar, feel free to reach out to Peter or Bob directly, and thank you very much.